So with that, People v. Turner.
Good afternoon. Erin Van Kampen of the State Appellate Defender Office, appearing on behalf of Tykeith Turner. With me is my co-counsel Jacqueline McCann and Lindsay Ponce. I will, using this handy clock here, keep track of my own time, and with the court's permission, reserve any time that does remain, if there is any, for rebuttal. I also waive my free fire zone. This court should issue an opinion clarifying 4 things. First, that in Michigan, there is a long-standing practice of imposing concurrent sentences as a package. 2, that a resentencing, the scope of a resentencing, includes lesser concurrent sentences. 3, that these long-standing principles apply with equal force to Michigan's juvenile lifers being resentenced under Miller and Montgomery. And 4, the defendants need not file motions under 6500 in order to be resentenced on lesser concurrent convictions where the court already has authority to resentence on a controlling count. In Michigan—
You don't literally mean the first thing, do you? All lesser convictions. You only mean lesser concurrent convictions that would end up with a lower sentence than the original sentence, don't you?
Yes, I intended to say lesser concurrent convictions. So if I omitted the word lesser, or concurrent, that was unintentional.
Well, by talking about lesser, it seems to me you're describing the conviction as opposed to the term to be served under the conviction. If, for example, the concurrent sentence is 4 to 5 years, and as a result of Miller or something of the sort, you eliminate the life without parole sentence, you wouldn't have that concurrent sentence necessarily stricken, would you?
I do think that case would still present similar problems to what are presented in this case, even if the concurrent sentence was lesser than the sentence that the individual could receive upon resentencing for murder.
What would be the prejudice under those circumstances?
Well, I think that situation, there might arguably be a reason to potentially treat it differently, but the bottom line is that sentence was still imposed by a judge operating under a misconception of the law and without an accurate understanding of that defendant's circumstances, inaccurate information, in other words. And so even though we think that that's a situation where perhaps no harm, no foul, the same sentencing errors would be in play.
So the opinion that you're asking this court to write, the one with four principles to be included, the first of which would be to require that all concurrent sentences, because everything presumably would be lesser than the life with or without parole sentence, but all other sentences would have to be reassessed and reconsidered in the course of the court's resentencing process.
Could be. Much in the language used by this court in Francisco, in Jackson, we're not saying that the court would be obligated to impose a different sentence, but that lesser sentence would be within the scope of a resentencing.
Okay, thank you.
So that the court has discretion to consider the other sentence if the court deems it appropriate.
It's not that the court has the discretion to resentence on those counts, period. The court has the authority to.
Yeah, and it can exercise that discretion by saying, I'm not going to disturb those sentences, or alternatively, I'm going to reimpose the same sentence for those convictions in the new judgment of sentence.
I think the latter would be appropriate if the court was operating under accurate information and an accurate understanding of the law.
But isn't the theory that those lesser sentences presumably have been influenced in some way by the court's understanding that life with or without parole could or couldn't be imposed, and as a result of the Miller decision, wouldn't we be reconsidering only those lesser offenses that had presumably or likely been influenced in some way, or just everything would be up for grabs again?
Well, in general, this court doesn't like to guess at what might have been influenced where the trial court relies on inaccurate information. And our appellate courts recognize that as well. So looking back at the Tucker Moore cases, for example, a defendant need not prove that the trial court would have imposed a different sentence but for its reliance on the unconstitutional conviction in order to obtain resentencing.
Well, if we didn't like to guess, I mean, wouldn't our presumption be that the court has in fact imposed an honest and honorable, a correct sentence in every circumstance, and that there's no need for resentencing at all?
Except for when there are legal errors in imposing those sentences. And legal errors can include a reliance on inaccurate
But
information.
the legal errors aren't with the lesser sentences. The legal errors are with the principal sentence.
Well, they were informed in very much the way Your Honor suggested. I mean, for Mr. Turner, he was sentenced to parolable life by Judge Moore, who believed two things to be true: that mandatory life without parole was a constitutionally permissible sentence for a juvenile, and second, that Mr. Turner would die in prison regardless of whatever sentence it chose to impose for assault. And it's that understanding that, basically, it was a legal and factual certainty at the time, but because of Miller and Montgomery, neither of those two things are true. And that's the shift that requires resentencing, and that informs...
That was my question. Those are the sentences that have been influenced in some way by the Miller-Montgomery decision.
Yes, because they were imposed concurrent with the life without parole sentence for murder.
Okay, go ahead, please.
And we're here in large part because the remedy for a constitutional violation has to be tailored to cure that harm and make the defendant whole again. Limiting resentencing under Miller and Montgomery to only Mr. Turner's murder conviction, as the prosecution and the Court of Appeals below suggested in this case, would require Mr. Turner to serve a parolable life sentence that doesn't reflect the careful exercise of discretion by a sentencing court with an accurate understanding of Mr. Turner's circumstances. And following his resentencing for murder, that parolable life sentence becomes Mr. Turner's maximum sentence and would prevent him from discharging even from the murder sentence if he served that entire maximum term. And finally, that controlling sentence, it would function as his controlling sentence, and that controlling sentence would entirely evade appellate review because of this court's and the Court of Appeals authorities that say that lesser sentences like a parolable life sentence for an individual serving life without parole are inconsequential. And so, for all of these reasons, we are asking this court to provide the clarification, and we think that the practices of the Court of Appeals, especially in these juvenile lifer cases, show the need for the court to provide that clarification because they've...
If we give the judge discretion, the judge could still reimpose the sentence that you're objecting to, right? There would be no legal barrier to the judge doing that, would there?
It would function much like Francisco, Your Honor. So the judge could, yes. If the judge had the accurate information, the accurate understanding of the law, and chose to exercise his or her discretion in that manner, that would be fine. Here, Judge Scott, upon resentencing, chose to exercise his discretion and determined that a sentence...
I understand. As we're fashioning a rule, though, I'm obviously thinking about a lot of cases to come and how it might impact those cases. In terms of sentencing is, judges do have a wide degree of latitude in sentencing and sentencing discretion within the boundaries, I guess, set forth by law and by this court's decisions. But in terms, and so I'm a little hesitant, though, to just say the court has discretion to resentence on a concurrent lesser sentences. I think you described them. As you described them, shouldn't we spell out a rule or try to tease out a rule that indicates that those sentences have some relationship to the sentence that was invalidated, legally invalid? In other words, what if the sentencing judge, gave an independent sentence on each one, and in that judge's mind, they weren't trying to have some relationship between the highest charge and the others? Sometimes judges sentence as a package, and once they sentence with the highest charge, whether it's life without parole or whatever the controlling sentence is, maybe they don't spend as much time thinking about what the lower sentences are because they're not material. But maybe a judge doesn't abide by that, and they do each sentence and spend exactly the same amount of energy and effort on each individual sentence. Wouldn't we say in that situation that those are not the type of sentences that the judge should have to revisit?
Not where they're concurrent, Your Honor, and that's because we have this norm in Michigan. Concurrent sentencing is the default, and because of how concurrent sentences are served together, even if a judge puts that kind of independent thought, we often see errors in the one that would infect the other. So the court's only required to say score the guidelines for the most serious concurrent conviction crime class. Isn't necessarily required. There is some ambiguity about that in the statutes, as referenced in the Mack case, which we talked about in our brief. But in general, courts only score the guidelines for the most serious offense. So when this court, say, finds an error in the scoring of those guidelines, the guidelines weren't scored for the lesser offenses, but often that scoring error reflects a reliance on inaccurate information that would have been similarly inaccurate as it relates to those lesser concurrent sentences.
But then the error of the misconception of law would have a direct impact, it seems to me, on the other sentences, or at least there'd be some relationship between the overriding sentence and the lesser sentences, right?
Justice Viviano is imagining a hypothetical where the judge did score the variables on every single one of the offenses
Correctly.
and carefully considered them, and it was correct, and there were no other problems. In that particular case, would you say there's no need for the judge to resentence on the?
And we're assuming there wasn't some error that was common to all of the guideline scoring. I mean, I think that's a difficult, I'm thinking about it because I'm thinking even in this case, I think that could still be potentially problematic. I mean, we're assuming in your hypothetical that the sentence would be, proportional under Milborn and not violative of, due process in some other way. I mean, I think that's a less workable rule. So one thing you said earlier that struck me was that we're asking you to craft a rule, and we're not asking this court to craft any sort of new rule. We have made every effort we can to distill this court's centuries, really, of sentencing jurisprudence, and also reflecting the common practices of.
The problem is when it gets to our level, whatever we say here becomes the rule, right? That everybody's going to have to follow if we rule in your favor. So we have to think a little bit about how this is going to play out, and if we do go along with what you're suggesting and recognizing this custom, it's no longer a custom, it's going to become established law in Michigan. And how is that going to play out? Again, not just on this case, but in the thousands of criminal cases that come into the court system every year, right? And so I'm just thinking, if we did give discretion, does it make sense for us to give some guidance on how the courts should exercise that discretion by thinking about resentencing on the concurrent offenses when they're impacted by, or may have been impacted by, the lead sentence in some fashion, which it seems will often be the case, but maybe not always.
So I think there are two ways to formulate this rule that we're talking about, two ways to frame it. And one is along the lines of this court's recent order in Gunn, that where resentencing means that a formerly inconsequential sentence will become consequential, the trial court has authority to resentence on those counts as well. But I think that formulation is less workable than a formulation that a resentencing on a count with concurrent lesser offenses includes resentencing on those lesser counts. And that's because it's not always clear until the resentencing itself whether a lesser sentence that was formerly inconsequential will become consequential. And so the cleaner rule is a full resentencing on the lesser counts. And I don't think that would burden the judiciary in any way because the court...
As a procedural matter, if there's a judgment of sentence on a case that involves multiple counts, and then we order resentencing on just one count, does the new judgment of sentence address all of the counts or just the one count that we ordered resentencing on?
My experience is that typically there is almost always only one judgment of sentence, even upon resentencing where the resentencing is limited for some reason. There are exceptions, and I think this case presents one.
But all the other counts would be republished in the amended judgment of sentence, just would be the same sentence, is that right?
Yes, I believe that is what would happen. Okay. So I want to be clear that we really aren't asking this court to chart new territory here, but rather to take our general rule that a resentencing, is a full resentencing, returns the case to a pre-sentence posture. That's got cases going back to the 70s like Ezell and Rosenberg, and also cases like McCracken, and this is important, and I want to quote McCracken on this because The whole reason we're concerned is that the trial court may not have put the appropriate amount of judicial effort into the sentencing decision and carefully weighed the sentencing factors because of its belief that certain sentences were essentially irrelevant. And that kind of speaks to a point that Justice Viviano and I think Justice Markman have already kind of alluded to. But it bears mentioning that this is not a new rule that we are looking for, and that general rule has some very limited exceptions in Michigan, and one of them is consecutive sentencing. The prosecution has urged this court to treat this situation like consecutive sentencing and not like all the other resentencings that happen in Michigan. That doesn't make sense, especially because the reason we are here is because of a constitutional violation. Not just and while there is a due process right to be sentenced based on accurate information, here it was the sentence itself that was imposed on Mr. Turner when he was 16 that is violative of the Constitution in itself. And so resentencing, curing that harm, necessarily requires the trial court to at least be able to consider imposing some other sentence on the lesser count, because guess what? It now may matter.
Can the judge increase the sentence on the lesser count?
That would depend. That would potentially trigger due process concerns related to vindictiveness. So the court would have to have some objective basis for doing so. So if, say, the original sentencing court had imposed 10 to 20 and wanted to now impose 12 to 20, then there would...
What if the judge said, I thought because of this particular mix of criminal activity, you should be in prison for a long time, and now the U.S. Supreme Court said that the top offense, I can't give you the long sentence, so I'm going to give you a longer sentence for the next offense.
I think that kind of reasoning could potentially itself be violative of Miller. I've been talking with colleagues over the last few days, talked about a hypothetical of, what if the court said at the original sentencing, I have to give you life without parole for murder, but I think that's where you belong for the rest of your life, so I'm going to give you parolable life on the assault with intent to murder as well. And I think even in that case, we would still want to send it back for resentencing because the judge is making an additional error there of thinking that this person should die in prison regardless of their youth and the mitigating factors of youth that Miller speaks to. So that's not quite the situation we have here, but I do think it shows
If we
why.
come up with a rule here in the Miller-Montgomery situation, which is rare, relatively rare, but this rule would apply unless we just made it specific to those cases. To, again, the many thousands of cases we see where, I'm just sort of the be careful what you ask for thing. When you reopen those, there are judges who could then say, okay, fine, this one offense goes down, well, this other offense goes up. Goodbye.
Well, and I think that is true, assuming that there is no other problem with that sentence in terms of proportionality or due process.
The question assumes that it's legally permissible in other ways. Is there any reason why, and it sounds to me like you're agreeing the judge would have discretion, where you're not just saying the judge could only lower the sentence, the judge could also, if the judge deems it appropriate, following the law, the judge could increase the sentence on the other concurrent sentences.
And if in exercising that discretion, there's some new constitutional error, I bet they'll be
then
back
we'd have
here
to
and
address
they'll
that.
argue it to us.
Right.
I have a feeling-
Yes,
I have
so-
a feeling we'll hear about it.
I think you can tell as a defense attorney, I'm reluctant to ever say, sure, that's fine, but I also want to be clear that it's true. What's good, for the goose is good for the gander, and we're not here saying that this is the rule because it's convenient for Mr. Turner. We're saying it based on our review of all of the authorities we've presented in our briefs, our experience as attorneys who do handle resentencings in the Miller context and the general context regularly. This case is like Jackson. There was an error in the controlling count. In Jackson, it happened to be that the controlling conviction was invalid. Here, it's the sentence, but a sentence that is especially important because it meant that Mr. Turner would never be eligible for parole as a matter of law.
So when this court remands for resentencing for one of 1,001 different reasons, are we implicitly saying that on remand we think that all other sentences have to be reconsidered at the same time? Maybe this is what Justice Viviano was asking. I'm not sure about that, but is that implicit in that kind of remand that, well, of course, some of those other sentences might have been adjusted had they known that the Michigan Supreme Court was going to call that original or the dominant or the principal sentence into question? So everything has to be reconsidered because we don't know that the judge really calibrated his sentence the way that he needed to and that he has to do on remand.
Yes, that is correct.
So my question, so you're answering my question by saying that when we remand, when this court remands for resentencing, everything is necessarily up for grabs, not just the principal sentence or the one that we're directly and immediately addressing.
Well, concurrent sentences. There are a couple of other the consecutive sentences are different in Michigan, so those may not necessarily be on the table under Miles and cases like that. And there may be reasons to argue that those cases should have come out differently, but Miles is controlling when it comes to consecutive sentences. I have 6 seconds left, and I do want to save that for rebuttal, but we ask that you reverse the Court of Appeals and affirm the trial court below.
And good afternoon, John Voital representing the people of the state of Michigan, in this particular case, the appellee. I think I'm willing to waive the free fire zone, the 2 minutes that were provided to me, and answer any of the court's questions that you may have, if there are any questions. I guess if forced to do a free fire zone, then I guess I will.
Do you disagree with counsel's suggestion about sort of the background norms of how this usually happens, or how, how?
Well, I think you have to look at it differently because this is a different case. We are dealing with a statute that addresses what resentencing will look like when it is ordered by that statute, and not as this court issuing an order saying we're ordering resentencing, or the Court of Appeals ordering resentencing just as a general term of resentencing.
But apart from that, procedural entry mechanism, do you agree about the background norms? When we order resentencing, how does it usually go?
Typically, when the court does, or the Court of Appeals orders resentencing, yes, it does go back as all sentences are on the table once again. Now, whether the judge decides to change it or not, all depends on the circumstances of that particular case. Okay. And again, this poses a different situation because we are dealing with a statute that has ordered the resentencing. So we're not dealing with an order from this court or that states we're remanding this for resentencing. We're speaking of a statute saying, yes, this case needs to get resentenced. And now, what gets resentenced? You look at the language of the statute. The statute says the court is going to be resentencing on this particular offense. And then the court can issue either sentence to life or a term of years. And so that's where we start from, is that this is not a general remand from the Court of Appeals saying resentence. This is a specific directive from the legislature as to what you need to do on this resentencing. Now, after that's completed, defendant is more than capable of making a challenge to the concurrent sentences, the other sentences that may have existed. Going through the court rule in that particular instance, the 6.429, the resentencing court rule, and going through that procedure. Go through that procedure, then that can put the issue back in front of the court to decide whether the concurrent sentences are invalid in some way.
So you're saying the silence in the statute means silence? It doesn't?
Not in the statute. The silence from, if a court orders.
I'm talking about the statute enacted by the legislature in response to Miller. The silence in that statute, I thought you were saying the silence in that statute implies that there's no obligation on the part of the trial court to resentence on the ancillary or the concurrent sentences.
I don't think it's silence. I think it's the court, this legislature speaks specifically in that statute of resentencing will occur and will occur on these, the set number of life sentences that pose a mandatory life.
It's silent on the other sentence.
But it's silent on the other side. And that silence on the other side, because the court has, or the legislature has spoken specifically to, I don't think the court needs to say, we're only going to, I don't think the legislature needs to state in the statute that we're ordering resentencing on this count and this count alone, and then continue on saying, oh, and none of the other cases. I think by the legislature specifically saying we're only ordering resentencing on this count and resentencing on this count, I think it's speaking specifically without having to go to the next step and saying, and by the way, you don't have to address any of the other sentences.
This is sort of an unusual scenario, right, where the legislature by law requires resentencing with, it appears, looking at the statute, without a court order.
Yeah.
They say if X happens, all defendants in a certain class will be resentenced, basically.
Yeah.
And here's what the sentence will be unless the prosecutor files a motion and asks for something else, right?
Right. And then once we get
But-
through the Montgomery defendants, then it's an issue that I don't think is going to arise again. But I mean,
I understand, but I mean, it's an unusual statute.
right.
So why should we say, I mean, I understand your argument, but why would we interpret the statute if every other case, when we resentence, we handle it a certain way? Why would we not think that the legislature, when they talked about resentencing here, was thinking of exactly that, the way we handle every other case? And that's how this case would be handled. In other words, why should your interpretation be the default interpretation instead of the opposite, which also appears to reflect the status quo?
Well, because, again, the court is obligated to take the statute as written. And I don't, in my interpretation, I think the statute is clear as to what is being ordered. And what is being ordered is just the resentencing on that. Now, to get into, there's you know, for this court's purposes, there's the idea of finality, that all these other sentences, every sentence at that point, actually, has gone through the process of being able to be challenged, be able to be determined whether it's a valid sentence. And after going through all this process, including motions for relief from judgment that follow the direct appeal, all the sentences have been deemed to be a valid sentence. Now, the legislature speaks up based upon what the U.S. Supreme Court has indicated, that there needs to be resentencing on this class of felonies. And the legislature spoke specifically to that. And that's what the idea of the legislature was when they did this, was that we are addressing specifically these cases that fall under Miller, and not to any other case that's already been deemed to be a valid sentence. Because Miller and Montgomery have determined that only these class of felonies and these classes of sentences are unconstitutional and invalid.
But for example, the statute only says, I mean, it says what the sentence would be. It says each victim shall be afforded the right under law, under the Van Regenmorter Crime Victim Rights Act, to appear and make an impact statement. And then it says those resentencing hearings shall be held in the following order of priority. So when it's talking about a resentencing hearing, I mean, it's not talking about everything that happens at the resentencing hearing, right? I mean, in other words, does the court just call the case and say, is the victim here? Yes, no, okay, we're done. Here's the new sentence. Or does the court, you know, conduct a hearing and allow counsel to be heard and consider what the court normally would consider at a resentencing hearing, which, again, if what we're told is correct, would normally include whether resentencing is appropriate on the other concurrent, lesser concurrent counts.
There is a whole hearing on that sentence itself. Now, the court was addressed with this issue back when Montgomery was decided, where the court had all of these cases that had been presented to you by applications for leave to appeal, which you held in remand, or you held in abeyance until it was time to issue orders on these. And every single time that this court has interpreted it, the language of this court's orders were, we are vacating this sentence. We're remanding it for resentencing on this sentence. That was the mandate of this court, was just this sentence. And when the court, a lower court, a circuit court, went beyond the mandate of this particular court, the Court of Appeals was quick to understand, nope, that's not what the Supreme Court said. And that's in Wines. There's other cases that we had. I'm thinking of Kincaid was another case that we had. But Wines is the one that's published in the Court of Appeals, where the Court of Appeals interpreted what this court stated in its orders was the circuit court is only obligated to vacate the sentence on this one count, on this one sentence, and resentence on this one count, and can't proceed to the other counts without a motion for resentencing presented by the defendant.
That's the Court of Appeals interpretation of the statements in our orders, correct? Where arguably, you're saying that at the time that maybe we operated under the understanding that resentencing, when we vacate the one, that the trial court will in fact consider the lesser concurrent sentences.
And again, I think this court does speak clearly through its orders. And if you look at the language of those orders, which were, I think, extremely clear as to, we are only allowing resentencing on this one count based upon the U.S. Supreme Court's opinions in Miller and Montgomery. Yes, that was the interpretation of the Court of Appeals, but I think it's the correct interpretation based on the clear language of this court's orders.
Orders have to be understood, and I haven't gone back and looked, but in relation to what the request for relief was as well, right? What if the party's only focused on the one count, then our order is only going to be directed to that count. In other words, the issue that we're talking about now, I don't believe was before the court when we issued those orders. Do you have a different understanding?
Well, my going back to the original point of what is generally done is the court states, we're remanding this for resentencing. This court has issued many of those orders saying we're remanding this for resentencing in the court, and I'll go along with the interpretation that normally means a general remand. And again, much like the legislature did in speaking specifically, this court spoke specifically and didn't just say we're remanding this for resentencing. It said we're remanding for resentencing on this count and on this sentence only. I mean, I can't see how it was any clearer by either this court's order or the legislature's
Counsel,
language.
can I just understand a practical, I want to
Sure.
make sure I understood your view of how it should go. So I think your position is that it's only on the mandatory life without parole sentence the defendant is automatically entitled to resentencing per the statute. But then if the defendant believes that the concurrent sentences were also affected, it can proceed by motion.
Right.
And it sounds like you believe the court can then resentence in response to that motion. Would your office not object then? I mean, is this really just like a procedural? Like you just want a motion to be filed with the?
Well, yeah, I mean, and that's filed, and I mean, it's sort of the same situation as Comer's involved. What Judge Viviano said is when this court makes a rule.
Let's not go all Comer on this here.
Yeah.
No, go ahead. That's just.
But I mean,
trying to-
but that's the situation of it, is that you have a statute that says you're going to get resentencing on that. So in order to proceed further, you need to go through the court rule, which allows it. Now, once the court rule is done, defendant meets the procedural requirements for getting it in front of the judge. The judge can look at this and say, okay, well, your claim is that this is an invalid sentence. It's not an invalid sentence. I'm not going to grant you resentencing.
But that's the same as, I mean, I'm just, for practical purposes, I don't know why it's that much better for you or your office than not to just let the judge in its discretion, in his or her discretion, say whether or not it was effective. I mean, I imagine there'd be some cases where a judge would say, like, no, I want the defendant to have that same sentence on the underlying offense or a worse one for some, and they have, assuming they have a basis for that. But I guess I'm just trying to, if your view is the statute lets them be resentenced on the life without parole offense, and then you're not going to object if they file a motion and the judge says, yes, my sentence on the lesser included concurrent offenses were affected, so I'm going to resentence on those, and then the prosecutor's office is going to say, okay?
No, what we're going to do is, and much like we did in this particular instance, is that they file their motion for relief from judgment. I think they're a little premature in filing their motion for relief from judgment in this particular case, but let's say that there is the Montgomery rehearing.
Yep.
And then defendant afterwards files motion for resentencing.
Oh, you think they have to go stepwise, so they have to first get resentenced and then they have to say. Right. So we need a second hearing, we just need 2 hearings?
Right, exactly, because that's
Okay.
what the statute allows. Or that's what the statute and the court rule require.
Okay, so let's keep going. So they do the same, so they get resentenced.
So-
And Judge Scott says, nope, I'm only allowed to resentence you on the top count, but,
Okay.
come
So-
back and file a motion
Right.
on the others. And then
So-
your office does what?
So they file their motion. In this particular instance, it was a motion for relief from judgment.
Yep.
We said, okay, if you want to file a motion for relief from judgment, you have to meet the procedure requirements that this court has required upon you to make a motion for relief from judgment. You did not meet your procedural requirements, so therefore relief should be denied.
So they'll never actually be able to get resentenced on the underlying ones.
If they can meet the procedural requirements, they can.
So when will they be able to meet them, in your view?
So, for instance, let's say if this is their first motion for relief from judgment, okay, which it doesn't exist now, so now we're going beyond the facts of this particular.
No, I know, I'm just trying to understand how it plays out.
This is their first one. Much like we did in this particular case, I don't think we're going to get much of an objection from the prosecution that good cause is shown, because obviously you weren't aware that this was an issue until then. Now you have to show that there's actual prejudice, and then to show actual prejudice, you need to show that this is an invalid sentence. Our argument is going to be, at least in this particular instance, where the record exists, on this record that we're dealing with, was that this was not an invalid sentence, so therefore, Judge, you cannot resentence on this.
You haven't answered my question. So far, they're gonna lose on prejudice. I'm asking, when will they ever win?
I'm saying that there are circumstances where the defendant can come forward and say, listen, this sentence, this lesser sentence was somehow connected to the higher sentence. So that could happen, okay? And much like it happened in Gunn, the case that they stated, where the judge at the time of the original sentencing specifically said, I'm going to give you this sentence only because I'm also giving you this sentence.
So when Judge Scott says here, I would have given a lot lesser sentence on the other offense, that doesn't count because?
Because, for a lot of reasons, which I made in my arguments. First of all, I don't think a life sentence is an invalid sentence because it was certainly accurate at the time. There's no misconception of the law at the time of the resentencing, so on and so forth. Everything was in my brief because I'm running out of time.
Yeah.
But
The life
But
with
there's also
parole
the-
was valid at the time, too.
sorry.
The life without parole was valid at the time on the murder conviction as well. But we're not in that realm anymore. Why is the validity at the time for the assault charge the determinative point in time in looking at it? We're
Well-
only here because we now have no longer a valid controlling sentence.
Well, what I'm saying is it's valid. The question is whether it's valid, continues to be valid. And I think the life with parole sentence continues to be valid now because it's still a valid sentence. You could still get a parolable life sentence for AWIM. There is no misconception of the law that occurred at the earlier sentence, and that's where I'm getting into what occurred at the original sentencing, is that you don't have, in this particular case at least, we don't have that tying together. We don't have what the existing record has is that Judge Moore, despite what Judge Scott said, did not just punt on this particular case, or punt on the sentence for AWIM. He specifically said that, listen, I hope to God that at some point you're able to get out on this mandatory life sentence. I hope it happens. And then says, now, but this is what I have to give you. I'm giving you a mandatory life sentence on that charge. Now, as far as the AWIM, I'm going to give you a parolable life sentence because it's my hope that well, he didn't say that, my hope, but he said, I'm giving you this life sentence, and the reason why I'm giving you this life sentence, parolable life sentence, is you can be paroled. If it should happen that your mandatory life sentence should get kicked out or you get commutation from the governor, so on and so forth, if you get any of those things, you have the ability to be paroled.
But the comments of Judge Moore at sentencing didn't suggest, gee, it's too bad that this isn't a parolable offense, and I have to choose between juvie and life without parole, suggesting he would have been somewhere in the middle.
Right, I mean,
Had he not had his hands tied.
On the
And so he
mandatory
puts the life without parole, and then it seems like he's on automatic pilot on the next charge. Why is?
I disagree with your reading of the transcript on that.
Well, what in the transcript suggests that he considered this completely separate, as you have just articulated?
Okay, so he goes, I think you have to read the whole transcript as incomplete and not just in piecemeal. So we have this entire long discussion, and I think it's extraordinary the amount of discussion that Judge Moore.
No, you remember Judge Moore?
I do. Well, he still visits on the bench, so I guess maybe it isn't extraordinary that he spoke for this long. But he did give a very reasoned, very helpful, heartfelt evaluation of the sentence that he was about to give, and why he felt that he hoped that there would be a middle ground, that there wasn't just between.
Do you really think so? Because maybe I read it differently. It didn't seem like that. It seemed like it was pretty clear as to what he wanted and what his intentions were. Am I wrong?
I think you're entirely wrong, yes.
Okay, and I appreciate you saying that. I mean, when I read it, it just seemed pretty clear as to what he was wanting to do and what his intentions were, and, you know, the whole component about society and protect, I mean, it seemed to me that he was making a pretty clear indication as to what his wishes were for the sentence.
I think when I read it, he indicated that I don't like to be placed in this position of I have to choose between a juvenile sentence and a sentence of mandatory life. I wish there was something that I could do in between, and I'm certainly going to speak to my legislature about it, so on and so forth. I mean,
Then
I
he
think
went on to be very specific, though, as to why he was making the ruling, the purpose behind the ruling, the decision as to why he was making the ruling, and he seemed to be very confident about why he had to make the ruling he did.
I think that well, my reading of the transcript is that he stated, I wish there was something in between. He said, there isn't, and this is the reason why I decided I'm going to give you a life sentence rather than the juvenile life sentence. And I think all his reasons were for, you know, I just don't think that you're going to, in whatever short period of time that you're going to be serving a juvenile sentence, that you're going to be someone that we can release into society again. So he gave all these reasons as to why he thought that a juvenile sentence was not the appropriate sentence, which left him with the adult sentence, which was mandatory to give him a life sentence on that particular, life without parole on that. But I thought he was very clear in indicating that he did wish that there was something in between. But because those are
some governor, 20, 25, 30 years down the road, perhaps granting a pardon or a commutation, right?
Because those were only available ways at the way.
I understand, but is that an indication that, you know, that why didn't he then do a term of years on the AWIM? Your whole idea is he gave the AWIM because that's parolable.
Right.
So he did say 20, 25 years. He could have put those term of years in on the AWIM if he was thinking about it.
I think he did indicate that I'm giving you this life because it would make you parole eligible earlier. And I think, you know, if you look at Louis Moore, the case out of this Supreme Court too, is that was sort of the understanding of all the judges at the time, is that if you get a life sentence, you're going to be eligible for parole in 15 years, which is true. And you're going to be eligible a lot sooner than if I give you a long term of years, which is also true. He indicated that, I think Judge Moore did, and when he was sentencing on the AWIM sentence, is that I'm going to give you a parolable life sentence because it's going to allow you to be paroled sooner.
When's the soonest he can get paroled under the current scenario?
He is eligible right now. Mr. Turner is eligible to be paroled
Was that
right
after 25 years?
Pardon?
How many years had he served at that point?
At the time he became eligible?
Eligible for parole.
He didn't become eligible parole until we changed his mandatory life sentence to the term of years.
Which was 20, was it 25?
That was 25, I believe, and he was eligible in 2018, I believe.
So why does the AWIM, as it currently stands, when does that become prejudicial to him?
I don't think it becomes prejudicial to him because what happened.
Does it only become prejudicial if he's not paroled after 60 years?
I think well, first of all, we've had, in Wayne County, we've had this situation arise 7 different times in these Montgomery defendants. Of those 7, 2 of them have not met their eligibility date on the murder case, on the first-degree murder case. Of the remaining 5, 3 of them have already been paroled. The other 2 are Mr. Turner and then a second defendant. Mr. Turner is eligible for parole, and as the defendant has conceded in their brief, is that if this case was not up on appeal, he probably would have been considered for parole, and I think he would have had a good chance of getting paroled. And it's a good chance that next time he is considered for parole, he will be paroled. So,
why does this case have anything to do with it?
because my understanding is the Michigan Department of Corrections is uncertain as to what exactly his sentence is. Is his sentence the 20 to 27 that Judge Scott gave him, or is it life? Either way, he's eligible for parole right now. But they haven't chosen to go forward it because of the question as to what his sentence actually is.
Thank you, counsel. The case will be submitted. You tried, Ms. Van Kampen, but you failed. So you did well anyway. Thank you very much.